Hey there, Jim Miskell from the Estate Planning Law Group of Georgia. I wanted to take a minute to talk to you about some common mistakes. Well, really one big common mistake with powers of attorney, or a red flag, if you will. And this has to do with when powers of attorney are effective, because when you appoint somebody to be power of attorney, what you're really doing is extending your power to that person to be able to do legal and financial things on your behalf. And you want them to be able to do that when they need that power to be able to use it.
So here's the deal. I appreciate you joining the podcast. The podcast is information and education, hopefully a little bit of entertainment. The issues we talk about are really important, but it does not constitute legal advice. You shouldn't take action on anything you hear in my podcast or anybody else's. That's where meeting with a qualified professional to get legal advice about your situation is really important. So this is the disclaimer. I'm a lawyer. You knew I was going to have a disclaimer. Information and education and hopefully a little entertainment. That's what the podcast is all about. When you need legal advice about your situation, you need to get that from a lawyer representing you. Whether you meet with them virtually or in person, that's the next step. That's my disclaimer. Now back to the podcast.
The problem with what's called springing powers of attorney is that they're not active when you sign them. Springing means that they spring into action at some point in the future. You sign it, that power isn't going yet. Only when something else happens in the future does your agent have the authority to act on your behalf. This makes some people feel really warm and fuzzy. Okay, so I want to give power to somebody, but I'm not really sure I want to do that now. Sometimes it's out of a misguided impression that by giving power of attorney, you're losing some of your own authority, which is not the way powers of attorney work at all. They don't diminish your authority. What they actually do is make an extension cord from you to somebody else so that they've got that authority also, but you can still do what you need to do on your own behalf. But some folks are really worried about losing independence, and I get that, and I understand that, and that's why we take time to explain how powers of attorney work and hopefully get through that. But folks that do springing powers of attorney, sometimes that's the motivation. I'm not ready to give up paying my bills, so I don't want that thing to be effective yet. What I see very often is powers of attorney that say, this will not be effective now. It's effective when a doctor says that I'm incapacitated, or two doctors is the way I usually see it. Two doctors say I'm incapacitated, that you need a certificate from two doctors before you, power of attorney agent, can go do what you need to do on my behalf. Sounds good. Makes people feel warm and fuzzy. They sign it, everything's great. And then they rock on down the line. Mary called our office last September, and she called because her mom, Irene, was in memory care and had gotten to the point where she was no longer able to do things on her own behalf. Mary had this power of attorney that Irene had done for her so that Mary could do the things that her mom needed when it came time. Well, it came time that they realized, oh my gosh, we've run short on funds. We're going to need to get money out of Irene's 401k to continue to pay, and they needed it for the October payment. This is about the third week in September. So they called the office, or Mary called the office rather, and said, I've run into a problem. And the problem turned out to be that Irene's power of attorney said, you've got the authority, Mary, when two doctors are willing to sign a certificate saying that I'm no longer capable, that I have an incapacity. The difficulty with working with this comes in large part because doctors do diagnosis and prognosis. Incapacity is not a disease. It's a legal determination. Judges and lawyers deal in incapacity. Doctors deal in what kind of disease is it and what's the outlook, the diagnosis and prognosis. So doctors have lawyers too, and when you put something in front of them saying, we want you to make a legal determination, they're a little bit squeamish about doing that. So what I did when I spoke to her when she called the office was we started working on some formulations of these certificates, trying to get something that was palatable to the doctors to be able to sign. And we did that. And that took about probably 3 or 4 weeks to go back and forth with a couple versions. Mary got a couple doctors to say, that's fine, we can do it. That really only got her so far, though, because once Mary had those certificates saying that Irene was not capable anymore, that she had this incapacity, now Mary went to the custodian of the 401k and said, here's the power of attorney mom signed, and I know it says it wasn't effective immediately, but here's a couple certificates as well that say her doctors say she's no longer capable. And they said, what? So the moral of this story is that springing powers of attorney can sound like a good idea, but they're really difficult for the agents to work with on a couple fronts. One, it's hard to get that springing event to happen. In this case, getting the two doctors to sign off. And second, once you get that established, then convincing the folks that are holding the money that they should go ahead and honor the power of attorney. It's much more effective. And this is why I recommend in almost every situation to do a power of attorney that's effective immediately when you sign it. And while you're well, distribute that to the folks who have your money so that they know. In Irene's case, she should have taken it to the 401k provider and said, here's my power of attorney. I want you to put this in my records. She could have talked to her rep and said, my daughter, Mary, if I ever need anything, she's going to be the one. And if they needed any more information at that point in time, a signature card from Mary, an ID from Mary, anything signed on their letterhead from Irene saying, I really want this to be the case, they could have gotten it at that time. And the difference that would have made would have been day and night for Mary when in third week of September, she needed to get the October money. She'd have been able to just call up, say, you've got the power of attorney on file. You know, I've got the authority, so let's distribute some of that money. So this is just one thing to look out for as you're looking at powers of attorney and thinking how to set up this planning. Powers of attorney, again, one of those lifetime documents. You're getting somebody in place to act on your behalf to be a helper and not losing any powers to do that. But as you think about doing that, what's the smart way to set it up? Once you've got the right agent identified, then making sure that they're going to have the authority they need when they need it. The Estate Planning Law Group of Georgia, we're all about educating folks about the ins and outs of estate planning. So when it comes time for family members, loved ones, and trusted agents to do what needs to be done, they're ready to do it, and they don't have to go through a bunch of administrative hassle at that point. If you'd like to know more, contact the office. Our website, of course, is letstalkestateplanning.com, and you can get in touch with us there with any questions you may have. And always looking forward to seeing you on the next episode of our podcast, Let's Talk Estate Planning. Until next time, I'm Jim Miskell. Thanks so much for joining us.